Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, let us discuss a couple of cases, important case laws on res gestae. Section 6 of the Indian Evidence Act. Important cases are there. So, you may be knowing what is res gestae. Please remember. So, the relevancy of the facts which are forming part of the same transaction. So, directly they are not the issue. They are only relevant. So the relevancy will be there. So facts though not in issue, please remember, facts though not in issue can be connected with the fact in issue so as to form part of the same transaction. So they are relevant. Whether occurred at the same time, at the same place, or at different time, at different places. So this is what is called res gestae. It is very important principle as per section 6 of the Indian Evidence Act, and definitely it is relevant. This much you know. Now I am going to tell you a couple of very important cases, decided cases. Actually 2 of them are from other countries. First one is Rattan versus the Queen. Rattan versus the Queen, 1971. In this case, actually, the husband was charged with the murdering of his wife, but he claimed that it went actually it was a shot not intended for his wife, but it has grazed her, touched her. So that is his defense, and he has not intentionally shot her, but it may spoil. But the fact, the issue, now I will tell you the relevant fact. The victim called the police. Just before the murder, the victim called the police. And before the operator could connect her, the call was disconnected. Normally, you may be knowing. Suppose if you make a call to 100, మీ నెంబర్ మీ పేరు చెప్పొస్తున్నా, మీరు ఎక్కడి నుంచి మాట్లాడుతున్నారు, మా యొక్క 100 ఒంగోలుకి ఇస్తున్నాను, ఉండండి లైన్లో ఉండండి అని చెప్తారు. ఈ లోపల this was disconnected. Right? And then she was murdered. So here the police went there, 100 వచ్చింది కాబట్టి immediately the police went there and found the dead body at the scene of offense. So please remember the calling of the wife to the police, please come urgently, send a constable అంటే మాట్లాడింది ఆవిడ. So just before, suppose if it is an accidental death, she should not have anticipated. ఎవరన్నా ఆలోచించి ముందే మా ఆయన కాలుస్తాడని యాక్సిడెంట్ అవుతుందని తెలుసుద్దా? కాబట్టి yes, this fact, it is a relevant fact as per res gestae. Her calling 100 in advance just before the murder, yes, it can be taken as res gestae. It is proximate enough to show that the accused, she has accused of the husband's involvement. So it is not accidental, it is intentional conviction. Second case, Thompson versus Travenian. Thompson versus Travenian, 1971. Right. Here, same, the husband slit her neck. Bharta, I would go to question. The deceased was running out of the house with a bleeding wound on her neck. And she called out, she came to the streets and she started saying that, my husband called me, my husband, ayya na magudu champesadu అని చెప్పింది. This statement itself is enough to show that the husband caused death. Nobody have seen. ఇక్కడ important point ఏంటి, evidence ఏంటి, what you see, what you hear. So nobody has seen him cutting slicing the neck of the wife, but she came outside, she cried loudly. So this is a part, this has got a relevancy. ఇలా ఉంటాయి. Third case, please remember, so this is actually R versus Bedingfield. R versus Bedingfield. R means Regina. Regina versus Bedingfield, 1879. Right. ఇక్కడ ఇది నెగటివ్ ఎగ్జాంపుల్ గుర్తుపెట్టుకోండి. సేమ్ ద వైఫ్ విత్ ది థ్రోట్ కట్, ఇందాక స్లైస్ అన్నాను కదా, సో థ్రోట్ కట్, షీ కేమ్ అవుట్ సైడ్ అండ్ shortly just before her death she told her aunt, oh dear aunt, you see what what your niece has done. So this is not taken as a res gestae. She did not tell that man cut her throat. మీ వాడు ఏం చేశాడు చూడు, నీ అల్లుడు ఏం చేశాడు అందే కానీ, మీ అబ్బాయి ఏం చేశాడు అందే కానీ, what act he has done, she has not disclosed. So it cannot be res gestae. It cannot be admissible, not admissible. Suppose while coming out, if she stated that aunt, your son, your this niece, nephew has done this, anunte artham kabatti, please remember, so it is a negative example. And I think Indian case is also there. This is Sabir versus state of Rajasthan. So please remember here, in this case, ఏదో గొడవ అయింది, చంపేసిన తర్వాత ద విట్నెసెస్ రీచ్డ్ ది సీన్ ఆఫ్ అఫెన్స్ అండ్ దే సా ది అక్యూజ్డ్ రన్నింగ్ అవే. దే ఆల్సో ట్రై టు రన్ అవే. అతనికి లైఫ్ అండ్ డెత్కి వస్తుంది కాబట్టి ఈ ర్యాన్ ఇన్ అడ్వాన్స్, చాలా దూరం పరిగెత్తాడు. అల్టిమేట్లీ సమ్ ఆఫ్ దెమ్ వర్ ఏబుల్ టు చేస్ అండ్ కాట్ హిమ్. సో ప్లీజ్ రిమెంబర్, హీ వాజ్ ఫౌండ్ విత్ ఏ బ్లడ్ స్టెయిన్డ్ షర్ట్. Please remember, and he tried to wash them in the pond. So definitely it is res gestae. So these are the classic cases to prove the point of res gestae. So please read these cases and enrich your legal knowledge as far as Indian Evidence Act 1872 is concerned. Thank you.